Before we begin the webinar, no, before we begin or in discussion on the topic, let us first have some ground rules. For those who are new to the Zoom platform, participants are asked to mute automatically. It's actually automatically mute throughout the session. If you have question, you can click the raise your hand button and we will address your question, whether through this oral interaction or through a text or message through the platform. You can also maximize the chat box if there are pressing and burning issues that you want to relate to the speakers. The presentation will last around 30 minutes. The theoretical and conceptual framework of this particular topic. And then for the next 30 minutes to 40 minutes, we will have a sharing of existing community protocols by staff within the NTFP family, as well as participants in the webinar. Okay. So without much further ado, I welcome again our guest speaker, Attorney Jean Corpus, a lawyer from the Kankanai-Igorot tribe of the Mountain Province. She's very active in this particular field of the interface between intellectual property rights system, the Nagoya Protocol, CBD, as well as having grassroots work with various indigenous people's community in Asia and other parts as well. So Jean?
Thank you very much, Edna. Without further ado, because we really want to get straight into the topic this time, I will now start sharing the presentation. There. Okay. So as Edna mentioned, this is the third in a series of webinars on community intellectual property rights. The first session was devoted exclusively to looking at the tools available within the intellectual property system. Don't worry, I have a review prepared for you in this presentation. So you can be on the same page as those who attended the first webinar. Then in the second webinar in the series, we had a look at other ways beyond the intellectual property system. How do we protect our traditional knowledge and traditional cultural expressions? Now, for this third in the series, the intention is to zoom in more closely into this animal or tool that we call biocultural community protocols. Because from the list of all the available tools for protection, it seems that this is something that communities can immediately undertake. They can do it without any law prescribing it. There is support provided for these, the documentation and the development of these protocols within the Nagoya Protocol, for example, as well as other legal requirements. Okay, so shall we start? Okay, this is now the review that I was talking about in relation to the first webinar. As I said, the first webinar looked at the tools available within the intellectual property system that could be used to protect traditional knowledge and traditional cultural expressions. Again, because we're talking about TK and TCEs, maybe it would be useful to provide a brief definition of what these things are. Well, traditional knowledge, it's quite different from the subject matter usually protected under the intellectual property system. How so? Because it is generally developed within a collective context. Not just developed or created, it is also maintained within a cultural context and passed from generation to generation. Traditional cultural expressions, on the other hand, are the physical manifestation of traditional knowledge. Normally, knowledge is intangible, but when you put your idea into something that is tangible, something that can be read, something that can be viewed or touched, that is now a cultural expression. Okay, so we learned from the first webinar that the existing intellectual property tools can actually provide some type or some level of protection for TK and TCEs. Okay, so this is a brief review. Okay, this is an ice cube tray. It is an invention that provides a new or novel solution to a technical problem. Okay, that's not TK, but that is something that is usually protected under the patent system. Okay, then you have the books. Sorry. Books or other forms of creativity are protected under copyright. Okay, and then we have trademarks that usually protect brands. And it's a useful tool for business because once your brand is established, many people would prefer to buy your brand over the other brands. And we can see here immediately two types of trademarks, a collective trademark and a certification mark. That's the sumac songko. If you can see from the picture, it's meant to certify the quality of potatoes produced by indigenous peoples in Peru. And then you have Toy Iho further down. It's a something that it's a mark that certifies that something is produced. It's a genuine product of the Maori people in New Zealand. Okay, so obviously trademarks has been extensively used to protect some forms of traditional knowledge of indigenous peoples and local communities. Then you have geographic indications, which is normally used to protect agricultural products, and industrial design, which protects the aesthetic qualities, the touch, the feel, the look of certain industrial products. Okay, and then you have trade secrets, which is the recipe for Coke. That's a highly protected trade secret. Now here are some examples of types of traditional knowledge and traditional cultural expressions that have been protected using our our intellectual property system. So you see there, the last one, the last picture I put on the screen is a weaving pattern. Okay, so industrial designs protect the look of certain things, so that is protected by an industrial design. The only problem is that it expires after 5 years, the protection. Okay, so you have to renew. So those are the names. And under geographical indications, if you recall from the first webinar, we discovered that it doesn't only protect agricultural products, it also protects cultural products. So this is a hat, the Monte Cristi hat, and it's protected by a geographical indication because it is produced through a 600-year-long traditional process by people in Ecuador. Okay, and then you see a carpet from Australia, and copyright was used to protect it against copying, unauthorized copying by other artists. So we can see here the means by which the traditional intellectual property system is used to protect traditional knowledge and traditional cultural expressions. So let's see if you have absorbed what I have been talking about so far. There is a poll, okay, and this is on the definition of traditional knowledge. So can we launch it? So read the question carefully. It says, what is not an element of the definition of traditional knowledge? So you have maybe 60 seconds total to answer. So if you think that all of them are elements, then you can answer none of the above. If you think none of them are elements, then you answer all of the above because the question is in the negative. Okay, last 10 seconds. Okay. Okay, I can see that maybe the way that the question was formulated was a bit confusing, but passed from generation to generation is certainly an element of what traditional knowledge is. It forms part of the traditional lifestyle of indigenous peoples and local communities, definitely. It includes know-how and innovations, but not practices and skills. Maybe this is where we were a bit confused. That is not an element because in the definition, it includes the know-how, innovations, practices, skills, as well as other traditional practices of indigenous peoples. Okay, so that was the answer. Let's just proceed and hopefully we learn more as we continue with the webinar. So note that all of the answers here in this question are elements of the definition of traditional knowledge, except for the third one, okay? Because the third one excludes practices and skills, whereas they are definitely elements of what traditional knowledge is, okay? So shall we move on? That was the review of the first webinar. Oh, let's go. There was one little picture that I neglected to explain, and that was one from a weavers collective among the Tiboli people in the southern part of the Philippines, in Lake Cebu. And that is a certification mark, which is attached to products called the tinalak cloth to certify that they were produced, that this tinalak cloth is produced using the standards developed and approved by the Weavers Collective, or in short, the owners of the collective mark. Okay. Now, in the second webinar in the series, we reviewed the different types of protection. And here's a diagram that looks at the international system for protection. Under here, we see trade, the uppermost. Then this is administered by the World Trade Organization. And there is such a thing as the trade-related intellectual property rights. So it provides very strong protections for intellectual property. And then you have, moving to the right, counter clockwise, you have under the biodiversity regime in the international system, you have the Convention on Biological Diversity and the Nagoya Protocol that provide protections for traditional knowledge. However, it's not very highly enforceable, not like the trade regime. And then you have food and agriculture under the Food and Agriculture Organization International Treaty on Plant Genetic Resources for Food and Agriculture. There is also a recognition of traditional knowledge of indigenous peoples and local communities there. Also the human rights system, and such as the UN Declaration on the Rights of Indigenous Peoples, and even International Labor Organization Convention number 169 on Indigenous and Tribal Peoples. However, like the Biodiversity Convention, the protections provided here do not have very strong enforcement mechanism, not like the trade treaties. Then you have UNESCO, which is the preservation approach to protecting traditional knowledge. Okay. And then you have, of course, the intellectual property system through WIPO. And under these conventions, there are discussions ongoing for international level protection of traditional knowledge and traditional cultural expressions. Okay, so that's a brief review. Now we look at the specific tools that we identified. We said that there are a variety of measures available, such as legal measures. Those are laws, basically. Then we have some approaches within the system called defensive protection. And this means that you prevent, these are measures that prevent others from illegally using your traditional knowledge or from claiming that they were the ones who invented or discovered the traditional knowledge that you have. Okay? It's like a shield. Then you have the practical measures. These are measures usually used by maybe either public or private institutions, and they are not legal measures because there are no laws that require it, but they're included in the rules of certain institutions and organizations. And then you have our, of course, community protocols and international protection. Okay, what are these? Let's look a little bit, let's review it a little bit more thoroughly. Okay, so as we said, in New Zealand, they adapted slightly. They changed some provisions in their trademark law. Okay, and it says that marks or trademarks cannot be registered if they are offensive to the Maori, who are the indigenous peoples of New Zealand. Okay, and in order to determine whether the mark is offensive or not, they had a Maori advisory committee. So, for example, this is the application for a trademark for a beer, ale, and to the right, cigarettes. So these applications were referred to the Maori Advisory Council, and they were rejected because they were offensive to the Maori. Okay? That's an example of an adopted national law. Then we also looked at the national, the law of Peru. It's sui generis legislation, which means it's in a class of its own. It's not your usual intellectual property law. Okay? So it's part of the system, but it's different. Same but different. Okay? And it created an agency that would protect intellectual property, but it also looks at protections provided for traditional knowledge. So in this law, they have a definition of traditional knowledge, and that is not something that you normally find in regular intellectual property laws. Okay? Then, as we said earlier, the defensive protection, this is the shield, prevent others from unlawfully using your traditional knowledge. So this was the Traditional Knowledge Digital Library in India, okay? And it protects yoga, unani, and siddha, which are basically medical systems that the Indian people have used since time immemorial, since forever. Okay. And then here's an example of the work of the Peruvian Commission Against Biopiracy. What they do is they look at all, well, not all, but patent applications in the most, in the countries that have the most patents or patent applications. That's China, the European Union, the United States, and they look at whether there are traditional knowledge from Peru that are being sought to be patented, okay? Or that there are patent applications for. And they've been successful in preventing patenting of some of the Peruvian plants, okay? And this is an example of a practical measure. We don't need a law, so you avoid this whole legislative process, which sometimes takes a very long time. So here, this is a library that has sound recordings, okay? Ethnographic sound recordings. And there are rules on how these recordings will be used, okay? And it says, and it recognizes here that there needs to be consent also from the source of the recordings, even if the British Library is the acknowledged copyright holder, okay? So that is a practical measure. And then you have guides, best practice guides for certain events that tend to attract people to showcase their traditional knowledge. So one example is festivals, very popular here in the Philippines, and I'm sure in most of your countries as well. So these guides would provide rules on how the spectators in the festivals can or cannot use the traditional knowledge showcased in the event. Okay? So, and then of course we have community protocols, but before we proceed to our review, since this is going to be the meat of the presentation, we have another poll question on what we have reviewed so far on the different tools outside of the intellectual property system to protect traditional knowledge. So can we launch the next question, please? Okay. So what is an example of defensive protection? That is basically the shield. Okay. So we're looking for the best answer, okay? Because of course the other options can also provide defensive protection. Okay, last 15 seconds. Okay, so the best answer, because it's the best known whenever you mention defensive protection, it's the best known answer, is the TKDL. However, of course, the other types of tools, the other tools given here can indeed also provide defensive protection. Okay? Yes. Okay. Maybe the next best answer would probably be the New Zealand Trademarks Act, no? Because it prevents registration of offensive traditional knowledge. But of course, the TKDL is almost synonymous with the term defensive protection. Okay, so there's another one. There's another question. Can we flash it? Can we launch it? Okay. Practical measures. This means that it doesn't require a law. Okay, we have 60 seconds. Practical measure. Okay. Okay. Oh, most of you got it this time. It cannot be the Trademarks Act because that is a law. So it's the best practice guide on festivals. Okay. Well, that was just a review, so I hope we got some information. But now we go straight. Okay, there's a question now. Before we proceed, I am receiving a question. Yes.
So Jean, there are many cases now in Southeast Asia where people are into traditional medicine. So in the Philippines, we have a traditional medicine law, but I think in other countries as well, but I'm not as familiar. Here in Manila, UP Manila came up with a digital library for health practices or these traditional healing practices. So I think it is TK also, just to prevent an exclusive claim of other people on these already known indigenous practices related to health. So here I'm looking at their website. I don't know if this can be flashed. This is not as much not sure if it's clearly related all on traditional knowledge, but it's with traditional healers. So is this also a form of defensive protection? What is your take on this?
Yes. Yes, in fact, it really is a form of defensive protection along the lines of the TKDL. And the history of the development of the digital library being managed by the University of the Philippines in Manila is actually presentations from WIPO, the World Intellectual Property Organization, because they are promoting the use of digital libraries as a form of defensive protection. Okay, so they told Filipinos, representatives of the government from the Philippines, about about the Indian TKDL, and our government thought that it would be interesting to have it, since we have a lot of knowledge, a lot of traditional medical knowledge that we fear might be patented in other countries. So yes, definitely that's included. Yeah, actually I should have used it as an example because it is closer to home. The only issue here is that in contrast to the Indian traditional knowledge digital library, sorry, is that the TKDL of India includes in the database published uh, published uh, documentation of various forms of Indian traditional knowledge. And since these types of knowledge are really widespread throughout India, in short, it's difficult for them to identify which community specifically originated the knowledge. It's considered the property of the entire Indian population. Okay? In contrast, here in the Philippines, while there are some types of knowledge that are really widely used in the general populace, there are also some forms of traditional knowledge that are known only to specific indigenous communities. And our input when this information gathering was taking place was that for those types of knowledge where you can identify specifically the community that originated it, there still has to be some sort of consent process before it could be used. So it's not sufficient that you look at the database of the UP Manila and then start using, you know, the knowledge, assuming that it's already in the public domain or that nobody owns it. There has to be some form of annotation identifying the community that it comes from so that the consent of the community can be obtained before use of the knowledge. Okay. Okay. I've been informed that there is a question, but I cannot see it. Can you let me know what the question is?
So the question G is that what traditional knowledge is generally, as you explain, would be it's a collective knowledge, and usually this collective knowledge are passed on to generation and generations and could be widespread. So what have been the practical measures in countries where traditional knowledge is recognized, but the actual holder of this traditional knowledge is not actually specified? What has been the practice? Do they go into a national fund? What has been, and what is your take as well as guest opinion, expert opinion on this? Thank you.
Yes. Well, it's quite clear for widespread knowledge. Normally, it goes to a general fund. For knowledge that are shared across communities, usually there is an agreement among the various communities on whether or not to grant consent and on how the benefits, or what the benefits should be and how to share the benefits. If it's only one community, then the community should decide in accordance with their traditional decision-making structures. One example that I can think of is, well, a bit further from home, but in Canada, where the community approached a academic institution, a university. I think it was a medical school within the university. Okay, and they entered into an agreement to develop further some of their traditional medicines based on plants found within their territory. And the agreement was between the university and the leadership, the tribal leadership of the tribe that is the acknowledged owner, or that, that owns the traditional knowledge and the resources related to the medicine. Okay, so those are some practical measures or some approaches that have been undertaken in countries with this type of traditional knowledge. Okay, and in fact, thank you for the question, because it was it segues, it allows us to segue nicely into this whole idea of community protocols. Okay, so now, at the last webinar, we said that community protocols are rules, set of rules developed by the community, and it's based on their traditional knowledge and customary laws, and it specifies what third parties need to do in order to access or use their traditional knowledge. Well, the traditional knowledge of the community. Okay, it's about the community determining their own rules. Okay, and of course, necessarily, because each community has a different set of customary laws, then the protocol should be unique to each community. There should be also provisions for the dynamism and the evolution, the changing nature of customary laws. So it should be dynamic and evolving. And there is no template that can be used, no? Because they cannot, well, it's usually not the case that they are having the same set of rules. Okay, there's an example here, but I will provide other examples. Actually, you also will provide other examples later. But in this Australian example, it's a protocol for researchers, okay? And it includes things like requirement for confidentiality and requirement, the rules for who owns the copyright to the work that is produced based on their traditional knowledge. Okay. In the Philippines, actually, we have something similar. It is not just a protocol. It was elevated to an administrative rule from the National Commission on Indigenous Peoples. It requires all researchers who generate the knowledge from interviews or from interviews with the community, and it's essentially the same requirement. There has to be consent before the researcher can use the traditional knowledge. Then there has to be confidentiality as well, and the community must in all instances be acknowledged as a co-owner. Excuse me. Co-owner of the copyright. Okay. So, where does this from? Of course, community protocols, or the basis, more specifically, the basis for community protocols, have always been in existence for for indigenous peoples and some local communities. However, the first time that it was included in an internationally binding treaty was in the Nagoya Protocol. Okay, so let's review a little bit this Nagoya Protocol. What is it? And if we look at the preamble of the Nagoya Protocol, it says here that it fulfills one of the three objectives of the Biodiversity Convention. If we recall, the objectives were number one, conservation of biodiversity. Then sustainable use is the second objective. Then we have the third objective, which is like a sort of funding mechanism for the first two objectives. It recognizes that there are some communities that have preserved and protected their biodiversity such that the richness is some resources that have commercial application. Okay, and it recognizes the right of communities to benefit from the use of those resources. Okay, this was a difficult negotiation. Some say it was 10 years, but negotiations actually took 6 years before the protocol was adopted in Nagoya, hence the name, in 2010. First, first thing that I cited from the preamble, the legal this whole that of the traditional knowledge and genetic resources are found within indigenous peoples' communities, then it stands to reason that customary laws of indigenous peoples should be part of the enforcement mechanism of the protocol. Okay. Now, of course, some people, because they have no knowledge, or maybe because they have knowledge of customary laws, they were saying that, oh, this is so difficult, because how do we ensure legal certainty when community protocols differ from, when it wasn't community protocols yet, it was customary laws. These customary laws are not usually published. They are usually in an oral form, and sometimes, since indigenous peoples really have a holistic view of their lives, their culture, and their environment, usually these customary laws are in relation to everything about the indigenous community. So they said, how do we isolate the parts of customary law that are relevant for access and benefit sharing? And so that was one of the factors that led to the development of the concept of having community protocols. And then, of course, the preamble, the protocol also recognizes that this is the right of the indigenous peoples and local communities to identify who are the rightful holders of the knowledge within the community. And this is preserving sort of the collective nature of a community, because sometimes within a community, there may be specific persons, such as the medicine women or medicine men, who develop the knowledge, who hold the knowledge and who develop it. But this is an acknowledgement that decision-making still takes place within the collective, and it is up to the rules of the community to determine who specifically within the community should have a greater role in providing consent and in benefit sharing. Okay, I hope that wasn't too difficult, but these were the underlying tensions within the negotiations that had to be addressed, and the reason why the concept of community protocols came to be enshrined in the Nagoya Protocol. Okay. Let's see, I think we have okay, not a question, but a comment. Now let's move. This other provision recognizes the interrelation with the traditional knowledge and genetic resources. And this is because we kept on saying that it's so difficult to disaggregate or to separate tradition from resource. Okay. And recognizes unique circumstances. And finally, it states that the protocol should not diminish all the rights that indigenous peoples already have under other legal instruments. You recall that I mentioned the Declaration on the Rights of Indigenous Peoples, specific provision on genetic resources and traditional knowledge. And so the rights that are contained there. Okay. So, what are the specific provisions now of the Nagoya Protocol on community? This is not a poll. It's just a there. As I said, Nagoya Protocol is the first international legally binding instrument that recognizes community protocols. And you can see here in this provision that all countries, when they implement their obligations under the protocol, and I believe that all the countries represented here in the webinar have already ratified this Nagoya Protocol. And it says that the customary laws as well as community protocols and procedures taken into consideration by governments. Okay? And there is an undertaking here to support the Nagoya Protocol. So this is something we can demand from our governments, this support. Okay. Now, under awareness raising, it also specifies that all those who have ratified the Nagoya Protocol need to undertake awareness raising measures, such as awareness raising of community protocols and procedures of indigenous peoples and local communities. Okay, so again, this is something that would support proper implementation of the protocol. Now, once a community has documented and developed their community protocol, what can they do with it? Of course, they can keep it within the community, but under the Nagoya Protocol, there is also the concept of a national competent authority. And it is this national competent authority that is tasked to provide evidence of compliance with consent, prior informed consent, whether if it doesn't matter if it's consent of the state or consent of indigenous peoples. Okay, so the protocol recognizes two types of consent, by the state and by indigenous peoples. Okay, and it also recognizes the possibility of having more than one competent authority. In fact, during the negotiations, indigenous peoples raised the possibility of having an indigenous national competent authority. Okay, so there. So it would be good if those who have developed their community protocols would submit it to the competent authority, because then the competent authority would be put on notice that these are the rules when dealing with particular communities. Okay, so here, this is what I was saying. It's possible to designate one or more competent national authorities. Okay. Okay. And here again, you see that the competent authorities of indigenous peoples and local communities is also recognized. Okay. So you can see now how this concept of community protocols fits into the overall architecture of the Nagoya Protocol. Okay. So the concept is recognized, support is provided, and what to do once the protocol is developed is also provided here in the Nagoya Protocol. Okay. So, and this is from a toolkit from a publication of one of the leading organizations that has developed this concept of community protocols. So what is it? What is it? It's determined by a community, okay, documented, developed in a participatory manner. This is where some form of technical or legal expertise comes in, because as I said, it isolates, or it looks for that part of customary law, the body of customary law, that deals specifically with access rules and benefit sharing. Okay. And it's actually a clash of worldviews, such as this, no? In general, third parties who want to use genetic resources and knowledge have this concept of commodifying it. Of course, they want to access it so that they can use it for themselves and benefit, okay? So it's like fencing, like you see in the left picture. Whereas indigenous peoples, on the other hand, have this very integrated view of their biodiversity, their cultural diversity, and their identities, okay? So it's a sort of clash of worldviews, because when you begin to isolate the rules within customary laws that would go into the community protocol, the community has to grapple with this whole concept of commodification, no? But it's there, and the truth is that most communities now recognize that resources have to be generated in order for them to be able to continue with their traditional ways of doing things, okay? So there are some community protocols that I have seen that define or that address this problem of commodification. For instance, they would understand the need under the intellectual property system for inventors to have exclusive rights to exploit something for a set period of time, okay? However, they always specify in the community protocol that ownership by the corporation, by the third party, of the patent and the right to exploit does not exclude the community. In other words, the community can still access whatever resources were used, and once the time period for ownership by the patentee expires, that's usually 20 years, all rights would revert back to the community, okay? So that's one thing that can be put into the community protocol to address this clash of worldviews, okay? When developing the protocol, this is a sort of diagram that identifies the foundations on which a community protocol is based. From the top, you can see that it is recognized by international laws and policies. And this is not just the Nagoya Protocol. This is also the UN Declaration on Indigenous Peoples, other human rights bodies that recognize the right to customary laws and to resources, okay? There are also national laws and policies that recognize rules that a community may have for use of its resources, and other external actors or private entities, okay? Then you also have here at the bottom, which is the bedrock, the foundation of the protocol, are the aspirations, the vision of the community. Then you also have identification of the traditional decision-making structures, and finally, the identification by the community of what constitutes their biocultural heritage, okay? So this community protocols, which is the square in the middle, is an attempt to get those triangles from the top and triangles from below. It's an attempt to get them to meet, okay? So this is basically the concepts that underpin what the community protocol is. So how do we go about doing this? There are some examples, okay?
Okay. Thank you.
Yes.
Okay. Before we go into examples of protocols and how are these developed, maybe we can entertain some questions from the participants as well as from the audience here, because we have already covered the background actually supporting community protocols. I hope it's not too heavy, and I think G was explaining it well, It's an example as well as national experiences from other countries. So at this point, let's open the floor, open the platform for raising of hands, for specific questions, clarifications, or maybe sharing. Is the internet unstable, or people are still downloading all the facts that has been presented to them? Okay. Anyway, so now let's go into the developing the protocol. I think Jing is in her last 3 slides, and then we will open the floor for some sharing from our colleagues on developing some protocols.
Okay. I will actually not belabor some of the elements of how to develop a community protocol, because this is usually, these are usually the rules that are followed whenever uh, doing things or developing things in a participatory manner with communities. Okay. Of course, when we develop a protocol, it should always be defined and controlled by the community. Okay. It should always begin with the vision of the community. And it should always be based on the values held by the community. Okay. As you can tell, probably from this listing, this is taken from a guide for how to facilitate the development of community protocols. So it's actually addressed to third-party facilitators. So the assumption here is there is some level of trust between the community and the organization or entity that is assisting the community in developing their community protocol. Okay, and this trust should be built upon and should permeate the entire process of developing the protocol. Now, one problem when dealing with, well, not really a problem, but one of the things that we need to be alert about when dealing with communities is sometimes there is a tendency to privilege participation of, the traditional leaders who are usually men. And not to worry, when we suggest to the communities that they include women and younger people, they are usually open to this suggestion. So we just need to be conscious about being inclusive within the community. Okay. So dialogue is important, intergenerational learning as well, and recognition of diversity of skills. In fact, many communities that we have dealt with are very mindful of this. Sometimes they require members of the community who have already obtained education or higher education from outside to participate and to share their skills with the community. Okay. And usually the process in developing the community protocol would be the usual participatory processes. Whenever we do it with communities, we usually start with a visioning exercise. Okay? We ask their community about their vision for their community. Then we ask them to identify their self-determined priorities. I think this is already in the next slide. Okay, vision and priorities identified by themselves, that's why we call it self-determined, development priorities, okay? Now, once this vision has been articulated, this would guide the further development of the protocol, okay? Because the protocol normally would provide information on, well, not really provide, but there is a process of mapping and resource inventory. And this is in order for the community to recognize what they already have. It's not necessary. Sometimes the community would want this part of the documentation to be confidential. However, confidential or not, it is still a necessary part, no, in determining the other elements of the protocol. Then, of course, they have to identify the traditional governance structures. Who makes decisions? Okay, if someone comes and wants to use the resources of the community and the traditional knowledge, then there has to be an identification of what this procedure is and who or what institution within the community is going to make the decision. Okay. Now, we hear a lot about this concept of free, prior, and informed consent. Okay. In fact, if you look at customary laws, there are usually rules for consent, for getting the agreement of a community. Okay. And it's best to get them to articulate, to get the community to articulate exactly what these consent rules are. And then you put that, of course, in the protocol. Okay. What are the uses? When documenting the rules, it's also useful to have an eye towards future negotiations with users of the resource. Okay. So in short, there could be some rules included here on how to express the agreement. No, usually maybe to a memorandum of agreement. In the Nagoya Protocol, they use mutually agreed terms, and then also some sort of rules that briefly describes how the community intends to share the benefits, because this is something that is always sort of a concern raised when talking about customary laws. Okay? This is actually in parlance of other natural resource use. It's sort of like a procedure by which to obtain social license, from the indigenous community. So in broad strokes, that is generally how we have approached the development of protocols. And as Edna said, my next slide is actually a compilation of some examples. I think that I shall briefly flash the examples, but we should mainly maybe listen to others who would like to share their concrete examples. Okay, so there have been many developed. The protocols that we have been personally involved in developing are not listed here, but we have several within the Philippines. Okay, so this is the time, I guess, to open the floor to the participants for them to share some of the protocols that they have developed.
Thank you. Thank you very much, Jean. So we come now to the part where we share some of the examples of protocols, community protocols that were developed and facilitated by some of our colleagues in terms of NTFP, so non-timber forest products, such as honey and then abaca. So before you see those very nice weaving, there's a whole set of rules that the community developed towards having this very nice weaving. Okay. So for our first discussion, I would like to invite Julius Domingo. So Julius Domingo is from the CMCC, or the Custom Made Crafts Center. It is the green intermediary, or a shop or a store that is under the Philippine Non-Timber Products Exchange Program Office. And she would share to us experience of sustainable honey protocols and how was this facilitated, and some of the rules that were derived from this process. Julius, are you here? Hello? 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 Okay. And then the next one, we will have also from the NTFP Philippines, sharing of good Hinabi practices. So these are also examples of community protocols. Some difficulty in terms of connection. So I see Julius now on the line. Hello, Julius.
Hello.
Hello, Julius. I hope everybody can hear him.
Hi, that's Mike.
Yes, we can hear
Can you hear
you.
me? Okay. So I will be sharing on the Philippine Forest Honey Network. Through the initiative of the NTFP Philippines, a core group comprised of traditional forest honey harvesters formed the Philippine Forest Honey Network. So the formation of the network has led to the further improvement toward the guarantee of high quality of honey. Um, the standards and protocols and product research and development were done in the Philippine Forest Honey Network while ensuring environmental sustainability, cultural empowerment, and community enterprise viability. In the fourth year of the network, a set of protocol in sustainable harvesting, handling, and processing of forest honey has been established and implemented, and quality has been developed for forest honey, and it was introduced in the market as a premium commodity. So the manual and or protocol was coined from traditional practices of partner communities with the introduction of new sustainable methods. This protocol has served as guide among the members on the principles and processes to be followed by the network. And this is the first in the Philippines for the forest honey.
Okay. Yes. Thank you, Julius. So this is an example of a protocol that was developed by indigenous peoples in across the Philippines who are involved in sustainable honey harvesting. So you see here being flash is uh, is the example. It's actually a documentation of this sustainable honey harvesting uh, in Tagalog. Sorry, we actually have a English version. So and so this actually set some rules as well as, of course, sustainable harvesting protocol. Thank you, Julius.
Okay,
Um,
welcome.
so we now come to this another particular resource, which is the Abaca. You know, earlier on in the first webinar, I think Jing presented example of the tinalak as well as some of the products on weaving. And before that is actually brought to the market and developed by community, it has a long, rich traditional culture, you know, that has long been practiced by indigenous weavers in Mindanao. So Sarah Graciel Ang is here to share with us some protocols on weaving developed with communities. Hello, can you hear me, Sarah? And the next, we have a question on the platform after Sarah. Hello, welcome.
Hi. Hello.
Yes. So we would like to know more about these community protocols developed with Abaca weavers in particular parts of the country that you have been working with in the past years.
Um, Particularly in the Philippines, in partnership with the HIVOS project for the Switch project, we were actually documenting community practices in how different communities like the Higoonon community and the Tiboli community in starting from farming until their extraction process to dyeing process and their weaving practices. We've been documenting each of their groups' practices, but we're more focused on reaching quality standards so far here in the Philippines, and that's why we tried to move further by applying for a trademark, which we call the GHP trademark, in recognizing
Trademark.
not just yes, it's a trademark. We actually applied in the intellectual property office, the trademark division, in recognizing that for this mark, it does not only ensure that it's made out of abaca, but we also indicated in the protocol that they're quality made products.
Okay. Thank you very much. Thank you very much, Sarah. So there is actually a question from our participant, uh, Han. So Han, would you like to ask the question now? Okay. So it's actually, the question is being typewritten as of the moment. Okay. So, so as you can see, Jean, um, for the community protocols that we are developing for NTFP, it's actually a mix of documenting the traditional culture, as well as, of course, as said, traditional knowledge and practices that is into these NTFP enterprises. But on the other hand, we also try to make sure when these products are entering into markets, they are compliant with certain rules. What is particularly striking about the definition of community protocol is that it is also telling the identity of the particular indigenous group, their vision, as well as their access rules within the community, as well as access rules when a third party would go into the community to access the resource. However, I also noticed that in the case of the Philippines, since we have a legal requirement of the Ancestral Domain Sustainable and Protection Plan, those community protocols are actually a subset of a much bigger plan where there is actually those requirements. However, for our particular enterprises, we see the value of developing these community protocols, particularly on the aspect of enterprise. I don't know if this falls squarely into some requirements of the Nagoya Protocol, etc. But we are happy to say that this actually set also, aside from benefit sharing rules, set also the requirements of free prior informed consent. Not in an explicit way, but it is being also recognized along those lines. Um, so any comment on this, Jean?
Yes, yes, thank you, Edna. Yes, in fact, community protocols can be about anything. They may be community protocols that are documented for the purposes of using a certification mark, no? A certification mark within the intellectual property system actually certifies the quality of a certain product. And it also tells you that this product was uh, produced in accordance with traditional practices, no? Because there's a premium on being traditional in the international market nowadays. Um, a community protocol can also be about access and benefit sharing. However, in practice, you cannot be developing, it's very tiring for the community to be developing protocols for many different things. Yes? Because it's a time-consuming process. So what we do with communities is we make a larger documentation, and this is about all the different rules that a community has. Okay. In fact, it even provides penal provisions. It has penal provisions. In other words, the different types of punishments for infractions or violations of the customary law. No? So we have this bigger documentation, and then we call out certain parts of it for certain community protocols that's specific for either applications for trademarks, certification marks, or something that is more appropriate for the Nagoya Protocol, no? For community protocols under the Nagoya Protocol. Okay, it's best, I think, different strokes for different folks. So you can actually call out parts of the customary law that are relevant for the purpose that you're thinking of using it for. But yes, it has many different uses. And if you have it anyway, if you've already done it anyway, then it's useful to have it tailored for specific purposes.
Okay, thank you very much, Jean. So there is actually a question from another platform. I will read the question as it is. Please give examples of competent authorities that have been established by country's government to recognize community protocols, particularly for those countries who would not have an indigenous tribal office, just like in India or in the Philippines. And the second one is, please provide some concrete example where community protocols have been implemented and where they have been successful in protecting their biocultural heritage. So 2 questions.
Okay. National competent authorities are usually designated under the Biodiversity Convention. Okay. There are usually focal points on ABS, access and benefit sharing, for example. And well, I think now they call them focal points on the Nagoya Protocol. There are also, and there is a possibility within the Biodiversity Convention to designate a focal person under 8J, which is the provision of the Convention on Traditional Knowledge. Okay, I can think, for example, of Mozambique, one of the African countries. I think it's Mozambique, or starts with the letter M. I'm so sorry. It's but anyway, they have a focal person for Article 8J. And as you saw in one of the earlier provisions that I flashed, it's an option for those parties to the Nagoya Protocol to designate these focal persons, or focal points rather, as the national competent authority. So in this case, it was the focal point on 8J that was lobbied to be designated as the competent authority specifically on indigenous peoples. Okay, the same thing in Guatemala. There is an 8J focal point, and it hasn't happened yet, but they are lobbying for the focal point on 8J to become one of the national competent authorities under the Nagoya Protocol. Okay, here in the Philippines, we don't have a focal point on 8J, unfortunately, but as you said, there is an institution, which is the National Commission on Indigenous Peoples. However, I think it's useful to talk to our governments, specifically the agency that is in charge of implementing the Biodiversity Convention, the CBD, so that they designate a focal point for 8J, and that this focal point serve a dual purpose as also the national competent authority on national competent authority on access and benefit sharing, the Nagoya Protocol. Okay. Now, for the second part of the question, the community protocol, if you saw the list of examples that I flashed, that was developed by the Dusun communities in Indonesia, in Malaysia, in Sabah. Okay, it's been completed, and it's being used in the context of indigenous songs. Okay, so there are recordings that use elements of their traditional songs, the Dusun people, Kadasan Dusun, and it's the community protocol that is being used to govern uses of the music. Okay.
Thank you, Jean. So we now call again. Thank you, Jing. So we now call again Han. Han here is ready to ask some questions. Earl, can you unmute? No. Okay. So in that case, there is another question. I will call on now. So Han is, hello? Okay. So, Chrissy, um, Chrissy would like to ask another question. So, giving the mic to Chrissy now. Okay. So, now, okay, so Chrissy typed in her question. Actually,
This was
if
already read.
okay, so there's a Chrissy is here for the second question. Chrissy?
Can you hear me?
Yes, we can hear you.
This can you hear me?
But you have a
Okay, great.
but
Did you want to ask me now, or because my questions you already raised, or
that you have a third question on the use of CP to enforce
oh,
rights. Yeah, that was not yet asked.
okay. I was just wondering if there are already examples where indigenous peoples have used their community protocols to enforce their rights, meaning active live cases. This is also to give inspiration and guidance for other indigenous communities where maybe these frameworks are not so promoted and known.
Okay, thank you very much, Chrissy. Jing?
Well, the closest example from our actual work, um, well, and maybe it's not really a very good example because we already have a legal framework here in the Philippines, but this is in relation to a community in Kalinga, and it's our partner community. And the assertion is that because, as you know, here in the Philippines, there is an FPIC, a consent process prescribed by the law, by the Indigenous Peoples' Rights Act. And sometimes the communities really do not think that this very bureaucratic process is appropriate for their community. So in this case, the community protocol was used to assert their right to be able to completely control the consent process. So in short, they used it in order to say that it is not the government community consent process that would govern. Rather, it would be their own consent process. Um, uh, Maybe a more appropriate example for the question asked would again be other protocols that were used in countries that do not really have laws recognizing the rights of indigenous peoples. Okay, so it's in the list that I showed you. We have specifically in Iran, and these are the pastoralist tribes. They are not recognized under the law. However, their use of their community protocols have enabled them to assert their rights as indigenous nomadic pastoralists. It's the same thing in, well, in Malaysia, because the rights provided under the law are not that strong, and the intent of the community protocol developed by the Dusun community is to raise the standard for the rights that were that are provided. No, they're trying to say that they are entitled to recognition of a higher level of rights than the recognition provided in their current laws. Okay, so these are some examples from Asia. I could also cite one example in Africa, specifically in the context of the Maasai people in Kenya. In Tanzania. Okay, this is a community that we are assisting in relation to community-based monitoring and information systems for climate change. And under the program, they have requested that we help them develop a community protocol that would specify, the rules for dealing with the community. And as we know, in Tanzania, they do not have strong protections for indigenous people's rights. And so they are using this document to assert their rights, which should be provided under international human rights treaties, as well as the UN Declaration on the Rights of Indigenous Peoples. So this is a way that communities have used to raise the standards that are existing within their countries. No, it's sort of a way of forcing the government to take notice and to acknowledge that this is the rights that the communities, that the indigenous peoples communities should have.
Thank you. There was a very, very interesting discussion on committee protocols as well as thank you for the questions. At this point, I see no one has raised questions or has raised their hands. So I think this is the time to end. So thank you, Jean. It was a very great experience having you to guest for our first webinar series on community intellectual property rights. And in this particular section, we are really very happy to know more about the nature of traditional knowledge and how can this be protected under this particular tool, the community protocols. And in the coming months and in the coming years, we would like to have a deeper understanding of community protocols as it is being developed and practiced by indigenous peoples and local communities across Southeast Asia specifically. So in the next webinar, we will be developing something along the lines of Nagoya Protocol, maybe an orientation on the ABCs of the Nagoya Protocol. ABCs meaning access, benefit, sharing, and compliance, because Jean has raised and opened up this community protocol discussion within the framework of the Nagoya Protocol. So at this point, I would like to thank everyone for sharing with us your afternoon. And I would like to thank the HIVE team, Earl, Dazzle, Femi, and Liana for supporting this webinar series. Thank you very much. And we will send the presentation and then the videos in the coming weeks. Thank you.